We have another interesting question from Vipul Ji at Kotak Bank. He says that if an account is already an NPA and is it still mandatory to do the process for SMA 0, SMA 1 under the SME and give the restructuring or revival chance to that MSME after it has become an NPA? So I believe this judgment that we just
This
talked about,
judgment is talk about
basically
this.
this judgment simply says that the borrower here challenged the SARFAESI process on the ground that the opportunities that were supposed to be provided to me under the RBI circular when I was SMA 0, SMA 1, and so on were not provided to me, and therefore SARFAESI is illegal, and the courts have upheld that. So, Vipulji, perhaps in your case also, what needs to be understood is that what was the date when this became NPA? If the date of NPA was prior to the RBI circular, then of course this judgment will not be applicable on your matter. But in case it was after, then this SMA 0, SMA 1, and other restructuring related correspondences, if they are in place, they can protect the legality of the SARFAESI process per se. Everyone, and welcome back to our weekly webinar series. We are at episode number 156 today, and we are talking about all the recent judgments that have developed or developed further jurisprudence and SARFAESI law, making it even clearer as compared to what it has already been as per our previous discussions. Over to Anil.
Thank you, Ankit. So in this episode number 156, we decided to bring to all of you the latest judgments from Honorable Supreme Court and various high courts. And in case the time will permit, we will also discuss some of the important judgments from DRAT. Now, this SARFAESI and insolvency law, these are the two options available with the lenders nowadays. And the other options, of course, are based on the commercial wisdom, that is the any kind of settlement, may it be restructuring, may it be deferment of repayment, or even one-time settlement. So that is the other option which is available according to the policies of different banks and lenders. Insolvency and SARFAESI, these are the two important legislations as of today, which actually would help the lenders to recover their money, or in the case of insolvency, to resolve a company which is under financial difficulties. SARFAESI, which was in fact promulgated in 2002, has now seen 22 years of its existence, and the law is quite well settled. The main important part is that without approaching any court, the lenders can enforce their security interest, enforce their secured asset, realize the secured asset, and also can appropriate to their loan account without approaching any court. So the only thing which is required, which is where a court is come in picture, that is the only seeking the help of the local authorities for taking the physical possession of the asset. So the local authorities in that case could be DM or Deputy Commissioner, or even the CMM or CJM. So these are the various authorities where you can actually seek their help so that they are able to provide the physical possession of that asset under the SARFAESI law. So there are various we have seen in the last 22 years, this particular law has actually seen bad days and good days. The bad days were those where the borrowers, they used to take stay for any small kind of error from the lenders, and those stay would continue for longer, and the banks would actually find it difficult to realize their security interest. Now, secondly, there used to be delay in DRT, DRAT, and also there was a lot of interference from other courts like local courts, high courts. So those kind of interferences were also, in fact, it came under the way of the recovery of the lenders. Now, over these 22 years, the law has settled very well. In fact, there are various jurisprudence where it has been settled that the powers of local authorities like DM, DC, CJM, CMM, in fact, many times it has been adjudicated by the Honorable Supreme Court and also various high courts. And the maximum 60 days time has been stipulated to them. That maximum stipulated time is 60 days. The DM or the local authorities will not take more than 60 days. The primary days are 30, but the another 30 days can be extended in case they need that by recording reasons. So this is where the present law is. Similarly, the interference of high courts under Article 226 writ petitions, those are also kind of only restricted when there is something other than the jurisdiction of DRT or DRAT is the dispute. Like, see, the high courts, in fact, have actually indulged into various litigations, which is primarily for recovery of debt. However, they are restricted where there is a issue involved, which is other than SARFAESI process or procedures. In case there is any procedure, in case there is any dispute regarding the even validity of the mortgage, regarding the title disputes, regarding the like kind of succession disputes. So all these disputes are not within the powers of DRT. So therefore, the various borrowers, with the help of lawyers, they've started going to high courts with different kind of disputes regarding the disputes of title, disputes of succession, or even the concurrence of the other family members were not taken for mortgaging the property. So therefore, we actually can bring out to you some of the judgments which are really important for the for the SARFAESI. So the first such judgment which I would be bringing to you regarding this is from Honorable Supreme Court. It is in the case of Sanjay Sharma versus Kotak Mahindra Bank, and this judgment was dated the 10th of December 2024, and it was given by Mr. Justice B.V. Nagaratna and Justice K. Kotiswar Singh. So this judgment was regarding the legality of unregistered agreement to sell and power of attorney. FC, very important judgment, that if there is an unregistered agreement to sell and a power of attorney, and thereafter the borrower, in fact, pledges the same property to a bank and takes the loan, so that unregistered agreement to sell and power of attorney cannot be considered as transfer of title. So therefore, let me even first of all let you know the facts. It is a case of a small basement at Old Rajendra Nagar, and the sequence of the unregistered documents, which is allegedly transferring interest in that particular property, which is a basement. So in 2000, an unregistered agreement to sell and a general power of attorney was executed by one Champaben Kundia to her son Chandubai. And then Chandubai, in turn, sold this particular basement to Satnam Singh and Surinder Vadwa, and that was again through an unregistered agreement to sell and a general power of attorney. Then in 2001, this Champaben Kundia mortgaged the entire property. Now, first of all, this Champaben transferred the property to his son. Then after that, this Champaben mortgaged the entire property to Associate India Financial Services, and this particular loan was further assigned to Kotak Mahindra Bank. Therefore, the Kotak Mahindra Bank is into the litigation. Then there was a default, and the Kotak Mahindra Bank, in fact, enforced their rights under SARFAESI in 2006. The public auction was also done in 2010. Some Sanjay Sharma, in fact, was a successful bidder, and he deposited 7.5 lakhs of rupees, and the sale certificate was issued to him in December 2010. Now, when we see such kind of litigation, we also see that in the SARFAESI was initiated in 2006. Then the 2010 was the public auction. So the banks, in fact, couldn't do much at that time. Many things, in fact, was not good at that time. But now let us see the timelines. In fact, the respondent, he went to before DRT complaining the ownership via GPA and agreement to sell, because the Chandu, the son of the mortgager, he actually filed first essay before DRT, and the DRT order upheld the respondent number 2 redemption rights under section 13 subsection 8 of SARFAESI, because the respondent number 2 is the Chandu, son of the mortgager. He has the he was considered to be the owner of the property, and there is a redemption right available with the owner of the property, that in case he can pay, in case he, as per section 13 subsection 8, the he can pay, he can use this right of redemption, but that is only very restricted to before the publication of notice for the inviting quotations for the sale of the property. But Chandu, he in fact made an application after the sale certificate was issued, and he wanted to redeem his right under section 13 subsection 8. As per section 13 subsection 8, any owner of the property has a right that in case he makes full payment to the bank through the bank, then he will redeem his property back to him, and he has that right, and that right is restricted to the time that is before the publication of notice inviting the quotations. Even when it went to DRAT, the DRAT in fact set aside the order of DRT in 2014, restoring the auction sales. Then it went to High Court. High Court in fact reversed the appellate tribunal's order and reinstated the respondent number 2's redemption rights. And then it went to Sanjay Sharma, who actually bought the property. He went to Honorable Supreme Court, and the issues which was there in this particular case was whether this respondent number 2 had a valid and enforceable right over the secured asset based on an unregistered agreement to sell and registered GPA. This is the person who is the son of the mortgager, Chandu, and this person has a right or not based on the unregistered agreement to sell and GPA. This is one question of law issues involved before Honorable Supreme Court. And then the second is whether the auction sale conducted under the SARFAESI Act and the subsequent sale certificate issued in favor of the appellant was valid or not, because in this particular case, the original owner sold the property to his son. Then his son sold it to Sanjay Sharma, and Sanjay Sharma, and now the son is saying that this particular mortgage was not valid. When this auction, and then the third question was whether the redemption rights under section 13 subsection 8 of the SARFAESI Act can be exercised after the auction and issue of sales certificate. Now let us see how this court has deliberated on these issues. Does an unregistered agreement to sell confer any legal right or interest sufficient to set aside a statutory action under SARFAESI? What is the scope of limitation of the borrower's or third party's right of redemption under section 13 subsection 8 of the SARFAESI? Can an auction sale under SARFAESI Act be set aside in favor of a claimant with only equitable or unregistered rights? Whether a registered GPA and agreement to sell executed before the mortgage but unaccompanied by registered sale deed can defeat the rights of the secured creditor. The court said the appeal was allowed. Sanjay Sharma, who bought this property under SARFAESI, was held to be the owner of the property, and it was also held that this claim of Chandu, who is an unregistered, who holds an unregistered agreement to sell and power of attorney, did not create title or enforceable interest under section 54. did not create like a title under Section 54 of the Transfer of Property Act. Then the auction held under SARFAESI was lawful and the sale certificate issued to the appellant was valid. The right of redemption under Section 13, subsection 8 must be exercised before the sale is effected. Repeated opportunities were given to the respondent number 2, which were not in fact availed. So in this case, in case we tried to see what exactly Section 654 of the Transfer of Property Act says, it says that the sale is a transfer of ownership in exchange for a price paid or promised or paid or part paid and part promised. Now the sale made such transfer in the case of tangible, movable, immovable property of the value of 100 rupees and upward, or in the case of a reversion or other intangible things, can be made only by a registered instrument. In case of tangible movable property of a value less than 100 rupees, such transfer may be made either by a registered instrument or by delivery of the property. This is what is the Section 4 of the Transfer of Property Act says. Now, Ankit, this is a judgment which actually says that any title which is primarily based on the unregistered agreement to sell and power of attorney would not be considered as a title document. So the person sell to somebody else on power of attorney and then mortgage. So that is what the case is. I think you can add something which is, in fact, this is not only for SARFAESI, but even otherwise also it is very important.
I think two parts of this judgment that are very important. One, of course, that seemingly anyone who will read this judgment will understand how this borrower perhaps tried to create third-party interest through unregistered sale deeds, agreement to sell. And, this is something that we also see happening sometimes, but then this has been disregarded here. I think this was also a judgment after which a lot of people have started realizing that the properties where the title is held through this POA method under Section 54 of the Transfer of Property Act is something which is very difficult to manage or very difficult to establish that title. So that was also there in the news. But what is also important is the timely claim of this right of redemption. So in this case, the court has also punished this person who had the title on the ground that despite so many opportunities that were available prior to this auction happening, the right of redemption was never claimed by the so-called claimant or the owner of the property. So I think the timeliness is also important.
Yeah. So I think this is a very, very important judgment. So we thought that we should bring it to our audience. And I think now we can go to the next judgment, which is Silir LLP versus Sumati Prasad Bafna. Again from Honorable Supreme Court, dated 13th of December 2024, and from Justice J.B. Pardiwala and Justice Manoj Mishra. In this case, this is a case of Union Bank of India, where the Union Bank of India, in fact, gave a loan of 100 crore against discounting of lease rentals against a property in Navi Mumbai, and that loan was given to Sumati Prasad Bafna, and who is the respondent number 1 in this case, and the account turned NPA in 2021, and thereafter the bank initiated SARFAESI law and issued a demand notice. Between 22 and 23, the bank conducted 8 auctions to recover the dues, and it failed. And in 23, during the 9th auction, the Silir LLP emerged as a successful bidder, offering 105 crore, and that was 25% amount was paid upfront on July 1st, and the balance on July 27. The bank confirmed the sale, issued the sale confirmation in their favor. Now, let us see on July 27, and the year is June. The year is 2023. So when on 27th July 2023, the sale certificate was issued, the sale confirmation was given, and immediately after the first auction, when the 25% was deposited on 1st July. After 4 days, on 5th July, the borrower filed an interim application before DRT seeking redemption of the mortgage by paying the entire outstanding dues. Which was in fact 129 crore at that time. So the borrower, in fact, after 4 days of the auction, after the bank received 25% of the total auction money, the borrower offered the entire outstanding dues, and the DRT, before the DRT could decide, because the DRT was taking some time, before the DRT could decide, the borrower approached Bombay High Court by filing a writ petition in 2023, and Bombay High Court permitted the borrower to redeem the mortgage subject to payment of 25 crores on that particular day and remaining 104 crore by 31st August. Everything is happening in very, very quick succession. However, this particular action of the borrower by depositing 129 crore was after the successful auction, after the payment of 25% by the successful bidder. So that is the dispute, and the borrower deposited 129 crore completely. Bank accordingly gave no due certificate. Release deed was also signed, and the property was returned. Original title documents were returned to the owner of the property. Then thereafter, just to be safer, this third party, the owner of the property, in fact, transferred this entire property to One Greenscape IT Park LLP. It was transferred to Greenspace IT Park LLP through a registered assignment agreement, despite being aware that there is a pending proceedings before Honorable Supreme Court. Therefore, in the meantime, Sealer LLP had already filed an SLP before the Supreme Court on 21st August. However, on 28th August, this property was transferred. Now, the Supreme Court is considering one, that this particular Sealer LLP was the first successful bidder, paid 25%. Thereafter, the High Court allowed the original owner to pay 129. Bank was also hurriedly accepting 129 because for bank it was higher recovery. The bank immediately acted upon and immediately sold the property. The person who bought the property, he further transferred it. Like the owner of the property further transferred it. He might have taken this money from Greenspace IT Park only. And then Supreme Court, in fact, set aside the High Court's order, holding that the borrower's right to redeem stood extinguished once the auction was concluded. The court directed the bank to issue the sales certificate to Sealer, the successful bidder in the first auction, and refund the amount received from the borrower. And in compliance, the Sealer LLP deposited the balance amount, and the bank issued a sales certificate on the same day. So this is where what we are trying to say, the issues were basically the Supreme Court, in fact, framed issues. Did the respondent commit contempt by violating the Supreme Court's order dated 21st of September 23? Because the Supreme Court's order was, in fact, violated and there was a contempt. Was the transfer of property to Greenspace valid despite the Supreme Court case being sub judice? Could borrower continue proceeding before DRT even after the Supreme Court final decision? Was this ninth auction largely flawed, or could it be re-challenged after final orders? Now, the question of law, which actually came to the Honorable Supreme Court, the doctrine of lis pendens. Lis pendens, in fact, the doctrine of lis pendens in this case is something which is considered to be, once the suit is pending, or pending litigation, that should be considered a notice to the world, and any decision, whatever is to be taken, that should be subject to the decision of that court. That is what is the doctrine of lis pendens. And does it transfer during pendency of litigation without registration of notice under Section 52 of Transfer of Property Act, as amended in Maharashtra, still attracts lis pendens? the court finally said, yes, it attracts lis pendens, because the lis pendens is that when a litigation is pending before a court, that should be considered a notice to the world. And therefore, even if there is somebody who doesn't have any notice, if there is a litigation pending, that is a doctrine of lis pendens, that any particular decision, any particular transaction on that subject matter would be subject to that litigation. That is the doctrine of lis pendens, and that was applicable in this particular case. And then it also came to the doctrine of election and a Henderson principle. Now, the doctrine of election is that when there are two options available with a particular person, and then he has to opt one, he cannot opt two options at a particular time. Like in this particular case, it was can a litigant raise an issue like an auction irregularity in one forum, that is DRT, abandon it, and then go to High Court? No, he has two options. One, that he can go to DRT, and then the other, he can go to High Court. Like that is the case of election. So the doctrine of election says that you have to choose one. In case you have two options, you can only choose one. And in this particular case, he has chosen both. He went to the DRT while it was pending before the DRT. He went to the High Court. So therefore, like, it is also the kind of doctrine of election was also violated in this particular case. And then is the the Henderson principle. Henderson principle is something which is based out of a UK case, Henderson versus Henderson, where in fact this particular case also talks about the principle. It talks about the principle which bars relitigation of claims or issues that could or should have been raised earlier. Now, in the case of Henderson and Henderson, the UK court in fact decided that in the case of relitigation, no, the fresh issues cannot be raised. Anything which could have been raised before, that should have been raised before. It is not possible that you raise it in relitigation. So that is what is the, and that is what is the kind of with the Henderson principle. And the finality of the confirmed auction, and in what circumstances can the confirmed auction be set aside or not. So then the court observation in this case was, yes, the borrower and Greenspace acted in contempt of the court's order. The borrower and Greenspace. Borrower was the person who actually took the redemption of the property and immediately after that sold to Greenscape LLP. So they both were in fact acted in contempt of the court's order. But considering their belated remorse and willingness to comply, the court gave one final chance to purge contempt by surrendering possession and withdrawing cases. Then on lis pendens, where the suit was pending, the pending litigation, it was considered as a notice to the world. It should have been subject to the litigation. The court said the transfer to Greenspace during the pendency of the seller's SLP was void. That transfer was subject to the decision of the pending litigation, despite absence of registered list notice. But yes, it is normally a notice to the world if there is a pending litigation. So therefore, the doctrine of lis pendens is also applicable. And it applies automatically as a public policy. That's what was held by Honorable Supreme Court. And then the borrower cannot be allowed to reopen auction validly issues after choosing the SARFAESI proceedings, litigating the same cause in the High Court, and not raising the auction defects even after during the Supreme Court appeal. So the court condemned this case as a textbook case of abuse of the process and applied the Henderson principle. What should have been raised earlier cannot be raised again. So that's what was held by the court. And in this SARFAESI part of auction, the court finally said confirmed auctions are sacrosanct and cannot be set aside lightly. It can only be set aside on the grounds like fraud, collusion, or fundamental procedural error, not anything else. A mere delay in the notice period is not enough for setting aside a kind of auction which has already been concluded. So, Ankit, this particular case, in case we try to see the doctrine of less pendants, the principle of Henderson, and also the kind of the two things which were in fact very nicely adjudicated by Honorable Supreme Court. So one, that our audience must learn that if there are two options available, both the options cannot be availed. It has to be one. Either you go to DRT or you go to High Court. This is one. Number two, the Henderson versus Henderson, the UK case principle, that that is also very importantly where this says the whatever was should have been raised before, that cannot be raised in re-litigation processes, and the claims cannot be revised in the re-litigation, and also the other part, which is that the list pendants applies automatically, and that's something which is a very important. And also the SARFAESI auctions are sacrosanct. Therefore, any buyer, any successful bidder should feel comfortable that any SARFAESI auction, in case he participate, it would be sacrosanct. It may take a longer period in litigation. Litigation may be expensive, but these three comforts are in fact very, very important comforts given by Honorable Supreme Court. Yes, Ankit.
So these are, of course, these doctrines we studied when we were when I was doing LLB. So I studied all these doctrines, and of course, there are so many of these UK-based doctrines or UK law-based doctrines, which are, of course, something that help the jurisprudence in India. And these two, which are very, very well kind of talked about in relationship to SARFAESI, of course, are very important. And there again, this less pendants is again something that we experience, and we are rather fighting a case on that ground in NCLT, that since the matter was pending in NCLT, how can something happen with respect to that contract when it was already pending? So we kind of course, use this doctrine to talk about how an act was illegal, even if because the jurisprudence or because the litigation was still ongoing on that matter. So very, very important doctrines that we discussed, and I think many of the people who are listening to this will be able to use it in their day-to-day litigations to protect the interest of the CD.
But Ankit, I think we can move to our third judgment from Honorable Supreme Court, that is in the case of Central Bank of India versus Shrimati Prabha Jain and others. This judgment was given by Honorable Supreme Court on 9th January 2025, and it was given by, again, Justice J.B. Pardiwala and Justice Mahadevan. And this judgment is again on a kind of title of the property, the succession law, whether the DRT has the power to decide about the title of the property or not, which in fact, I started today's episode on the DRT doesn't have the power, DRAT doesn't have the power to decide about forgery, decide about title of the property, or handle the disputes regarding succession law. That those kind of issues cannot be resolved by DRT. Therefore, the High Court's intervention is required in all these cases. So this particular case, when this the father-in-law of the Prabha Devi Jain, in fact, was the Prabha Jain, father-in-law of the Prabha Jain, in fact, bought a property, and then the father-in-law died, and the land was inherited into equal shares by the Mahinder Kumar Jain, who is the Prabha Jain's husband, and then Mahinder Kumar Jain's brother, Sumer Chand Jain, who is the brother-in-law of the Prabha Jain, and then the wife of that means mother-in-law. So basically, there were three parts. One, the one that it went to the two sons and the wife. So that is the succession which has happened. And thereafter, even Mahinder Kumar Jain died. So therefore, the Mahinder Kumar Jain's share was in fact inherited by Prabha Jain. So therefore, after the death of Mahinder Kumar Jain, there were three owners of this property. One, Prabha Jain, two, Sumer Chand Jain, and three, the mother-in-law of the property. So three owners. Now, what happened is uh, uh, there was no partition which was affected by the Sumer Chand Jain, the one son of the father-in-law who bought the property, without affecting the partition. And he, in fact, unilaterally divided the suit land into smaller plots and sold them off. Unilaterally, the Sumer Chand Jain, in fact, without taking any permission from one is the mother and the other is the babi, and without taking any permission, he did that and he sold plots. And one of the such plots sold by Sumer Chand Jain was to Parmeshwar Das Prajapati, and that was through a registered deed of conveyance, which was in July 2008. And then this particular Prajapati mortgaged that particular plot to Central Bank of India to obtain a loan. And then there was a default. Then there was an action under Section 13, subsection 4, and the notice of auction was given. So the plaintiff means the Prabha Jain filed a suit declaring that the sale deed and the mortgage was illegal and void. Possession of the suit land should be given back to the Prabha Devi, and the damages and mesne profit, that was also the then the trial court. That particular application was filed by the trial court. The trial court rejected this plaint, raising two objections. One, that the suit was barred under Section 34 of the SARFAESI Act, which said that no other court can interfere in SARFAESI matters, and the civil jurisdiction was ousted. So that is what reason one. And then the second is that the court fee was not paid. And then the trial court, in fact, rejected on both the objections. Then the plaintiff, in fact, filed the appeal before Madhya Pradesh High Court, and High Court allowed the appeal, holding that and holding that the DRT had no jurisdiction to decide on title or validity or sale mortgage deed executed by non-borrowers. Plaintiff had paid proper court fee. Civil court's jurisdiction was not ousted under Section 34 of the SARFAESI Act, because this was the dispute regarding the title or validity of the sale or mortgage deed. And then the Supreme Court, in fact, the Central Bank of India went to Supreme Court and challenged the High Court's judgment by way of civil appeal, and it was again connected with 15 more appeals. Now the issue before the Honorable Supreme Court was, does Section 34 of the SARFAESI Act bar a civil court from questioning the validity of the sale deed or mortgage? Question number two, or issue number two before the Honorable Supreme Court: can relief of possession and declaration of title be granted only by the DRT under Section 17 of SARFAESI? Issue number three, whether rejection of plaint under Order 7, Rule 11 of CPC was legally sustainable. And then the questions of law: is the civil court jurisdiction barred in a case involving third-party claim of title over mortgage property? Does the DRT has jurisdiction to decide ownership title dispute between non-borrowers and borrowers? Can a plaint be partially rejected under Order 7, Rule 11 CPC if one of the players is beyond DRT's jurisdiction? Now let us see what the Supreme Court says. In fact, the Supreme Court dismissed the bank's appeal and upheld the High Court order. And the key findings of the Supreme Court was, the DRT has no jurisdiction to decide disputes on validity of sale deed, questions of title, inheritance, adoption, or partition, matters between persons not claiming under or through the borrower. Jurisdiction of civil courts is not ousted under Section 34 of the SARFAESI Act. The SARFAESI Act gives limited adjudicatory power to DRT, confined to examining whether the measures taken by the bank under section 13 subsection 4 were in accordance with the law or not. And regarding relief of possession, DRT can only restore possession to the borrowers or persons claiming through them. Plaintiff was never in the possession nor a borrower, hence could not have sought such relief before DRT. The word restore in section 17 subsection 3 means returning possession to a prior possessor. And even if, so these are the various discussions and what in fact the, so let us try to understand what are the learnings. One, that in case there is any dispute regarding validity of sale deed, validity of mortgage, inheritance, title of the property, adoption, partition, that can go to any high court or any kind of local court or trial court. Number two, this power of the DRT is restricted to whether the processes under the SARFAESI Act was followed or not. And the civil courts, including High Court, has the jurisdiction under section 34 of the SARFAESI law. And DRT is not the only court which actually can restore the possession to the borrower or the person claiming it through them. So that is the outcome of this judgment. Again, a very important judgment. One, that the disputes regarding title, disputes regarding the mortgage, that actually cannot be addressed by DRT. So this is what is a very, very important judgment. So Ankit, would you like to add?
No, I think it's pretty straightforward. So it's totally logical and taking the process forward.
So, okay, let us move to the fourth judgment of Honorable Supreme Court. In fact, we had earlier also deliberated on this judgment, which is Pronits versus the Board of Directors of Canara Bank. And this judgment was given in 1st August 2024. In fact, I would like to be very, very quickly go through this because, in fact, I had deliberated on one of my the videos which are only for 5 minutes. I had deliberated. So this is regarding the MSME Act, and the loans were declared non-NPA by the banks, and the clarification was done. In fact, this classification of NPA was done without following 2015 central government notification, which introduced the framework for revival and rehabilitation of MSMEs. And then it was subsequently revised by Reserve Bank of India in 2016. And it was issued under Section 9 of MSME Act, and then it was revised by RBI in 2016. So in this particular case, it was directed by the policy and the RBI that for any MSME, there should be a process of classification of that particular loan account into NPA. First of all, it has to be SMA 0, SMA 1, SMA 2. And in this process, in between this SMA 0, SMA 1, SMA 2, in case any kind of corrective actions were taken by the bank or not, in case any corrective actions were applied by the borrower or not, in case applied, then the bank has to act on that. And act on that means not always that it has to be rejected or accepted, but it has to be like the decision has to be given by the bank before classifying that particular account as NPA. First condition is that the account is MSME. Number two, the account must have been categorized in a slow process where first it will be categorized as SMA 0, SMA 1, SMA 2, and then the borrower in case comes up for any kind of corrective action, or the bank will offer them to submit any kind of corrective action that they have in mind. And in case that corrective action is submitted by the borrower to the bank, then in that case, the bank must act upon that, must take a decision on that. So this is what, and then finally, the MSME, the process of the bank classifying the account as NPA was challenged in Bombay High Court and arguing that it was the violation of that framework. The court, in fact, dismissed that petition, saying that particular framework was directory and not mandatory. However, the banks are bound to initiate restructuring unless the MSME applied. And then the Supreme Court said very clearly that 2015 MSME framework is mandatory or directory. Were the banks legally required to initiate stress detection and restructuring for MSME prior to declaring the account as NPA? Can SARFAESI proceedings continue without complying with the framework obligations? Therefore, in this Supreme Court, finally, the questions of law was whether Section 9 MSMED Act framework read with RBI directions under Section 21 and 35A of the Banking Regulation Act have statutory force or not. Then, in compliance with this framework, compulsory for scheduled commercial banks before classifying an account as NPA, can a borrower be penalized if the bank fails? Can a borrower be penalized if the bank fails to follow the early warning mechanism? Finally, the court held that the Bombay High Court judgment was set aside, and the Supreme Court said that the framework, 2015 framework, under Section 9 of MSMED Act, along with the RBI directions, is a statutory binding, and it is mandatory. It is mandatory, and it is not directory. And any bank account, in case it has to be classified as NPA, it has to go through the process and procedure as per this 2015 framework. It is mandatory. It is a mandatory pre-NPA process, and it is the mutual responsibility of the bank and the borrower. And this is and the SARFAESI proceedings not automatically invalid, although the MSME fails to assert its claim before classification as NPA. And however, non-compliance, the banks make SARFAESI proceedings vulnerable if challenged timely. So the Supreme Court said that it is mandatory. It is mandatory, but it doesn't become automatically invalid. That was only a protection to bank, but basic law that actually the Supreme Court decided that MSME, in fact, was a valid and binding framework. So this is what is the 4 judgments, and then we can actually talk about some, in case there are some questions, Ankit, or we can take some questions before I move on to some High Court judgments.
No, I don't see any questions, but I can request the participants that in case they have any questions, they can either raise their hands or they can put the question in the Q&A box. We'll be happy to take that up. We have 2 raised hands, so I'm allowing them to talk. Mr. Kasi Visweswara. If you can, sir, please unmute.
Yeah. Sir, good morning, sir.
Good
Actually,
morning.
in case of this Stellar LLP, you said that this doctrines and all that are there, no? I just give me 1 minute, sir. I'll just frame my question before.
Sure. In the meantime, I can go to Mr. Ranjan. Mr. Ranjan, you can unmute yourself, sir.
Sir, is this 2015 framework of RBI is also applicable to FIs, financial institutions?
Yes, it is applicable to financial institutions also. This MSME framework of 2015, which is again reconfirmed by RBI in 2016, is applicable to financial institutions and banks, and also the
NBFCs also.
NBFCs also, because in case they have to categorize the account, classify the account as NPA, so they have to go through that process. And in case that process of categorizing the account as NPA is not done, then it can be challenged that the account has not been classified as NPA in that process. So it can be challenged.
Sir, in this Sanjay Sharma versus Kotak, actually this right of redemption under Section 13(8) be exercised before sale is affected.
Yes.
That is what you said.
No, not before the sale is effected. It is very clearly mentioned in Section 13, subsection 8 of SARFAESI that this redemption right can be exercised before a public notice is issued for selling the asset. before a public notice is issued for selling the asset. And once the public notice is issued, then in that case, the right of redemption actually will be lapsed.
Suppose if he has exercised that right of redemption before 1 minute. Suppose if he exercised the right of redemption before sale or an auction proceedings, in what way he will get a title on the basis of unregistered agreement to sell?
No, see, on the basis of unregistered agreement to sell, where he has the possession and a power of attorney, and in case he can definitely say that he would be able to give the entire money to the bank, and that is still valid. That is still valid. It may be based on the kind of, see, let us understand what is the ultimate objective of the SARFAESI. Like he can make the payment to the lender, full payment. And then the property will be released to the person who is mortgaged it. And then this is a third party, because see, that is also handled by the Supreme Court, whether the third party can also act for redemption of the property. So it is said, yes, it can be, and that the third party can also get this property redeemed, even if the third party is not the borrower. So he was not the borrower, but he wanted to redeem the property. So that is what is the case. So third party can also redeem the property, but the time of redemption is before the issue of sale notice under SARFAESI law. So there is a question, Ankit. I think we can see that question is there.
So we have Ms. Swati Bhaskar. The question is, please advise any case law of Honorable Supreme Court which has held that DRT is not having jurisdiction to decide upon any fraud or forgery element perpetrated by any of the parties relating to borrower and or guarantor.
I think this is, again, I will be coming to that judgment from ANCLAT, and I am coming to that judgment. Maybe this is the judgment which I am now showing it on the screen, Sandeep Goenka versus Yes Bank. And Swati ji, this is a judgment which is dated February 25, and it is from Justice Sabyasachi Bhattacharya and Justice Uday Kumar. It is from High Court of Kolkata. And in this particular case, what happened is Sandeep Goenka, the appellant, he claimed to be the 50% owner of the property, jointly held with his late brother, Hari Ram Goenka. Yes Bank claimed to have granted a loan to Hari Ram, secured by equitable mortgage over the entire property alleged with Sandeep Goenka as a co-borrower. Sandeep Goenka disputes this. He says, Sandeep Goenka says, he denies ever signing the loan agreement or any mortgage-related documents. He alleges that his signatures were forged and documents relied upon by the banks were fabricated. And then the bank relied on these judgments like a loan agreement, a letter of continuing guarantee, a net worth certificate, a memorandum of entry. But this magisterial declaration, which was not produced in the court, as you understand, the magisterial declaration is when this intention to mortgage the property is given, and that was missing. Importantly, many of these documents did not bear signatures of Sandeep Goenka. And timeline of the legal action, Sandeep filed a civil court seeking a declaration of his 50% ownership, declaration that loan and mortgage documents are false and void, an injunction restraining Yes Bank from taking possession. See, in November 24, first SARFAESI notice was given under Section 13, subsection 2, and in December 24, a fresh SARFAESI notice was issued, and the date of appeal, the trial court refused ad interim injunction without assigning any reason, prompting the present appeal. So this present appeal, now the question of law which actually came to Kolkata High Court, does Section 34 of the SARFAESI Act bar jurisdiction where relief involves title declaration and forgery allegations? Can the DRT grant declaratory relief regarding ownership, fraud, or forged documents? Is an ad interim injunction maintainable when SARFAESI measures have not been yet begun? Now, the court in this case held, one, that the civil court has jurisdiction. DRT jurisdiction under Section 17 SARFAESI is limited to examining whether measures under Section 13, subsection 4 were taken as per the Act. DRT cannot adjudicate title disputes, decide forgery allegations, or grant declaratory reliefs. Section 34 bar did not apply to suit which was rightly filed in the civil court. Prima facie case of ownership and forgery, it becomes because the 50% was claimed as the ownership. The loan documents relied upon the bank did not bear his signature. Bank failed to produce critical magisterial declaration it relied on. Appellant allegedly fabrication of grantee documents. This was also raised. No SARFAESI measures yet. The suit was filed before any notice under Section 13(4). So therefore, the no remedy under Section 17 SARFAESI was even available, reinforcing the court's decision, and injunction was justified. The balance of convenience favored appellant. He risked being ousted without being a party to the loan. Civil court's refusal to grant injunction without assigning reasons was erroneous and violated the principle. This is exactly, Swati ji, something which actually is your question. Is that right? Or you think that, because see, this was also mentioned in the other judgment of Supreme Court, and this judgment on the case of Sandeep Goenka versus Yes Bank is an appropriate judgment for you.
No, I think this should be this should answer her question. We have another interesting question from Vipul ji at Kotak Bank. He says that if an account is already in NPA, and is it still mandatory to do the process for SMA 0, SMA 1 under the SME and give the restructuring or revival chance to that MSME after it has become an NPA? So I believe this judgment that we just talked about, basically this judgment simply says that the borrower here challenged the SARFAESI process on the ground that the opportunities that were supposed to be provided to me under the RBI circular when I was SMA 0, SMA 1 and so on were not provided to me, and therefore SARFAESI is illegal, and the courts have upheld that. So, Vipulji, perhaps in your case also, what needs to be understood is that what was the date when this became NPA? If the date of NPA was prior to the RBI circular, then of course this judgment will not be applicable on your matter. But in case it was after, then this SMA 0, SMA 1 and other restructuring related correspondences, if they are in place, they can protect the legality of the SARFAESI process per se. Then we have a question from Arun Kumar Srivastava. He says that whether petition both under SARFAESI Act as well as recovery of dues of banks and FI Act can be made. So the petition under SARFAESI is made under DRT normally when it is made by the borrower who is aggrieved by the SARFAESI process. SARFAESI is an out-of-court process. And of course, in some circumstances, when the SARFAESI is not readily available to the lenders, then the lenders approach the DRT under the recovery of debts due to banks and FIs. So this is how it normally works. Any scenario where you feel that somebody will go to the DRT under SARFAESI Act as well as the RDDB Act?
No, see, RDDB Act is applicable on some different type of cases where the SARFAESI actions are not.
Where guarantees there, where somebody wants a recovery certificate for
actions are not
unmortgaged property.
But then in case in case of RDB, any kind of OA which is under RDB Act, that if excludes any specific secured asset, then it is valid. That for part of the recovery, the lender has opted for RDB Act petition, and for part of the recovery, the lender has actually opted for the SARFAESI law. That is possible. So in fact, there are many cases where the banks, in fact, they proceed against enforcement of their secured asset, and also they file, as far as these guarantees are concerned and other recoveries are concerned, they file the RDB petition under RDB Act. That is also possible.
So I think we are done with the questions. I think we have
we can actually see this couple of judgments quickly. This is a judgment from on High Court of Karnataka in the case of Kailasam P versus Karnataka Bank. It was delivered in 20th of February 2025. And in this particular case, this Kailasam petitioner stood as a grantor and a mortgager for two loans. One, a loan of 2.90 crore in his personal capacity, and 8 crore loan was given to White Horse Network Services, and White Horse loan went bad, and there was a loan liability of about 12 crore, and therefore initiated the recovery under SARFAESI. And then the demand notice was issued, possession notice was issued, and public auction was also done. And then this Kailasam challenged the SARFAESI proceeding before DRT, and his main challenge was filed within 158 days delayed. He sought condonation, but DRT dismissed it. DRAT upheld the DRT's view, and then in fact he went to High Court and seeking the overturn of the orders of DRT and DRAT, where this delay in filing was not condoned by DRT or DRAT. And so in this case, the basic issues were whether can a debt recovery tribunal condone delay beyond 45 days under the limitation of 17 subsection 1 of SARFAESI Act? Is the limitation period under section 17 mandatory or directory? Can high courts grant relief when DRAT and DRT deny this thing? So in this case, the questions of law and then finally the limitation, the judgment was, in fact, High Court also dismissed the writ petition and upholded the DRT and DRAT order. No power to condone. The High Court held that there is no power of condoning the delay under section 17. So the maximum time is 45 days. The limitation does not apply to tribunals unless expressly provided. So therefore, the legislative intent is clear that the cases should be filed on time. So there is the High Court cannot interfere. High Court held that the delay of 158 days in filing DRT application could not be condoned. And another judgment, which is from Punjab and Haryana High Court in the case of Sarabjit Singh and Company versus Debt Recovery Tribunal. This was given in February 2025. So in this case, the Sarabjit Singh, he's a petitioner. He approached DRT Chandigarh and the stay on possession proceedings, and also for preponement of their interim. However, the Chandigarh DRT 3 Chandigarh, in fact, disallowed and dismissed both the applications, and saying that the board was heavy and there was acute shortage of stenographers and typists. So finally, the High Court said that no, the DRT cannot say this just because there was acute shortages of stenos and typists. The justice cannot be delivered. That is not something which is acceptable. And the DRT is a quasi-judicial body and should not have given this kind of administrative inconvenience reasons. So the dismissal on account of staff shortage is unwarranted. The duty of the presiding officer is to deliver justice. And the High Courts, in fact, High Court set aside that order, and it was directed to DRT 3 that it should actually be fresh hearing, and then it should be decided. So Ankit, this is what is all, because we have already concluded 1 hour, although we have many more judgments, but we will check in case there is no other fresh issue which comes up, then we can even come up with more of SARFAESI judgments in our coming, which will be 157th episode. Yes, Ankit.
Right. I think I don't see any further question or raised hand. So these were important judgments that we discussed today. So we can take leave from our participants and then take up the next topic or this topic in the next episode. Thank you, everyone.
Thank you very much. Because see, when you participate in big numbers, we definitely get motivated, and we will always say this is our way of learning. Thank you.
Thank you, everyone.